where I answer your questions. And I answer your questions live. Sometimes people submit questions ahead of time. You can always do that. Just reply to the email we send out. And otherwise, you can ask questions while we're live today. Just put it in the Q&A and I'll try to get to it. I always start with positive focus, and I guess my positive focus is the markets are bouncing back a little bit today, so that's good. And personally, I'm coaching my kids in soccer right now, and we had some good games this weekend, and my son probably played one of the best games I've ever seen him play, so it was pretty awesome. And let me share my screen. This button, hit this button, this button. And again, if you do have a question, feel free to put it in the Q&A if you didn't already submit it ahead of time. Otherwise, I think I have 6 or 5 questions to get through. All right, and let me close that. And if you do have questions, feel free to just reply to the email, or if you want to see how this applies to your situation, feel free to reply to the email, or you can always go to www.15chris.com, and that will take you to a spot where we can book some time on my calendar, have a short chat. All right, so first question, are you a fiduciary? That's, whoops, I didn't want green. Wanted yellow. Have you always been this in your professional life and all aspects of your business? Well, this is an important word, especially kind of in the financial world. So we have this hierarchy of advice. And at the lowest end, we have what we call suitability. So this is where someone has to make a recommendation that's suitable, but maybe not in your best interest. This would be like going to the butcher shop, asking for a piece of meat, and the butcher gives you a piece of meat that's not rancid. Is it what's best for you? Maybe, maybe not, but it's suitable for you. And so there's a lot of financial professionals that just operate from a suitability standard. If someone just sells like insurance, like at Northwestern Mutual, or not to say that it's bad or anything, they just have a different level of responsibility. Or if someone's, let's say, a broker dealer like Morgan Stanley or Merrill Lynch, they're selling stock, right? Or selling mutual funds or selling variable annuities. They just have to sell something to you that's suitable. And so in the financial world, you have either suitability or fiduciary. And here, that means they need to act in your best interest. And that's very different than suitability. So as a fiduciary, it would be like, my role would be as a dietitian to say, maybe you shouldn't go to that butcher shop, maybe you should go have a salad, right? Versus just, you walk into that butcher shop, you're getting meat no matter what, right? I would say, hey, don't walk in that butcher shop, let's go over here because that's in your best interest. And then on top of that, and this is something that makes kind of our practice relatively unique, is that I'm an attorney and I owe everyone, no matter what we're talking about, attorney-client privilege. Meaning I can't share information. I always have to be on the same side as the table as you. I can never put my interests ahead of your interests. I always have to act in your best interest. So there's a lot of people that operate just from a suitability standard. So there's a lot of financial professionals out there. There's fewer that are fiduciaries. And then where I'm at is I'm a fiduciary as well as an attorney. So no matter what I do, I always have to be acting in your best interest. I can't take off my attorney hat. So hopefully that's helpful. And the word fiduciary has been, the suitability in fiduciary, a lot of times from the public eye, it can be very confusing. And I'm not saying someone who just operates from a suitability standard is a bad person or anything like that, or gives bad advice. It's just they have a different threshold that they always have to maintain. And there was some changes of making everyone fiduciaries, but the insurance lobby kind of fought that. So So I have always been, yes, ever since I started as an attorney, always acting in client's best interest. And I look at it as like kind of what would I do if it was my grandma? That's kind of what I run everything through. And it's not hard to act in someone's best interest. Thanks, Mom and Dad. I think you raised me well in that sense. So there we go. Here's a question. Can I, okay, like I will get to that question shortly. All right. My father left me and my siblings a cottage. This is not uncommon. We have that family cottage up north or something like that. We want it to stay in the family. What can we do to ensure it happens? So let's say this cottage, dad passes away, and now this cottage is split between, let's say, 3 siblings. Okay. And dad sounds like dad said it just goes out right to the 3 kids. But now the 3 kids have kind of come together and say, hey, this family cottage means a lot. We want it to stay in the family. What can we do? Well, it really depends. But one of the things we want to do is, okay, the first thing we need to protect against is what happens if someone gets divorced, because now they're joints. So they're joint owners of it. Right. And we always talk about joint ownership is great for a married couple, but we don't recommend naming anyone else joint on the property. The reason is let's say one of the siblings gets divorced, where now that spouse might be able to take a piece of that property. Or if one of the individuals were to pass away, depending on how it's set up, now that cottage might go to an in-law who might go off and remarry. So a lot of times what we would do is we would say, okay, it goes to the 3 kids. So it goes to the 3 kids. Let me get the spouse out of there. And then what the 3 kids would do would put it into like a mini asset protection trust. Okay. And now that the cottage is in here, the 3 of them could be the trustees, so they're in charge of it. And then if one of the kids pass away, then we could say that their share would go to their bloodline. So it could go down to the grandkids. And now the grandkids would step up and be trustee of the trust. So it's a way to keep it in the family. And then the other thing so the first thing is kind of protecting that bloodline. If it is truly supposed to be in the family, we would want to keep it in the trust. I have a client we're working with where it's not a big value, but it was like the great grandpa built it back with his own hands back in like 1928 or something like that. It's on a lake. So it's meaningful. They want to keep it in the family. So if you want to protect that bloodline, then the 3 individuals could set up a trust as a way to do it. And I would suggest an asset protection trust. So if there is a divorce or creditor or bankruptcy, whatever is in the trust would be protected. Now, the other thing we need to think about is the liability caused by this hot asset. So the asset protection trust protects against kind of like one of the kids getting into a car accident, sued, and now they can take the property. But we always say real estate, it's like a hot asset. You never know when there might be a slip and fall. I met with a woman who, unfortunately, it was after the fact, but she wanted to get asset protection because her name was on a second piece of property that her son was staying in. And her son invited a lady friend over who got bit, her face got bit by a dog. And now that woman is suing mom for $750,000 just because her name was on title for the real estate. So that's what I'm talking about with a hot asset. And then in fact, her insurance company is also suing her too. It was a strange situation. So with this hot asset, what we might want to do is we might want to limit that by putting it inside of a LLC, a limited liability company. So now if there were to be some type of slip and fall or lawsuit, it can't spread out and attach to the other children because it's wrapped inside of that LLC. So if you want to limit liability because it's a hot asset, then you might want to look at an LLC. And then the third part of it is we might want to put together an operating agreement. So this talks about how do we run this cottage? Like how do we make decisions? Like what if one child doesn't put in to cover the taxes for the year? Like there's a whole series of things that we need to think about. How do you handle scheduling? What if one family wants to be there and they can't agree on who gets what weekend? So that's where the operating agreement would come into play. And ideally, these things get set up as soon as possible before there are any kind of arguments. And we have a series of things that we go through. Hey, these are the common issues. Let's make a decision on how we want to handle it. Are decisions handled unanimously or is it by a majority? So those are all things that are handled in operating agreement. So do you have to do that? No, but it just protects against some of the problems that may arise in the future. So typically, if keeping it in the bloodline is important, then I'd recommend that we do a trust. Again, we don't have to do any of this. If the kids just decide to sell it and it's not going to continue on, then no big deal. But if they want it to stay in the family, these are some of the protections we might want to build in. If they're concerned about liability because of the nature of that hot asset, that cottage, a slip and fall, then we might want to look at putting that LLC together. And then if we want to make sure that we handle any issues that pop up in the future in terms of family dynamics, then we might want to put an operating agreement together. So it's one of those things that seems simple. Yeah, just name my kids, do a ladybird deed, so it passes to the 3 kids and they'll take care of it. But if it's something that's important, we may want to build in some additional protections. So hopefully that's helpful. All right, let me see any questions, anything in the chat. No, we're good. All right. So next question. So now that Congress has backed off, I presume that would have only, oh, I missed part. So this was talking about step up in basis. So it sounds like, at least for now, they've backed off the idea of getting rid of this step up in basis. Where right now, the way it works, you buy something for 100,000, you die, it's valued at 200,000, and the kids sell for 210. There would be right now just $10,000. Whoops. There'd just be $10,000 worth of gains. But what the tax proposal had said is that, oh, no, we're going to get rid of the step up in basis. And now the basis coming to the kids would have to pay would be $110,000 worth of gains. So that's what we're talking about, where Congress has backed off repealing or getting rid of that step up in basis. And the question or comment was that this would only impact taxable investments, as qualified are either 100% tax or tax-free. And the answer is yes. So this is where we need to understand the tax nature of our assets, where we have taxable accounts. So this is like real estate, brokerage accounts, investment accounts, checking, savings. Then we have tax deferred accounts. This is like your IRAs, your 401ks, pre-tax accounts. You haven't paid any tax on it. And then we have our tax-free accounts. So tax-free are things like the Roth, which everyone knows, cash value life insurance or index universal life insurance. Those grow tax-free, 529 HSAs. So you're right. This tax deferred accounts are taxed at income tax rate. So whatever you pull out of here is taxed at whatever your marginal income tax rate. These are taxed at capital gains rates, which right now max out at 20%. Income taxes max out at 37%. And then the tax-free bucket, there's zero tax other than maybe a state tax. So we've been talking about how the government has been going after the tax deferred accounts, with taxes potentially going up in the future with the repeal of the Tax Cuts and Jobs Act. But then with the step up in basis, we saw them now attacking this taxable bucket as well. So that's why, again, the strategy has always been, let's get the money as much as possible over into that tax-free bucket and look at different strategies to do that. So yeah, the comment / question is right, that it's only affecting taxable investments. So if they repeal the step up in basis, it's really only affecting that bucket. All right. Okay, the house exception of $500,000, would it be used by an executor in closing the estate? So again, I mentioned that real estate is in this, real estate is in the taxable bucket right here. And you do have an exception, $250,000 or $500,000 if married, where if there are gains on the real estate, you don't have to realize those capital gains. And then the question is, when closing the estate, well, right now, I guess it doesn't matter because we still get step up in basis. So you wouldn't have to worry about that. Yeah, we still have step up in basis. So you don't have to worry about using the exception upon death because we have step up in basis. And it wouldn't matter whether we use a ladybird deed or a legacy trust. A ladybird deed is basically just a beneficiary designation for your home, meaning it's in your name while you're alive, and then upon death, it goes to whoever we've named on the ladybird deed. So it avoids probate. You get step up in basis. You'd still get if you were to sell the house while you're alive, you still get the capital gains exception. And then a legacy trust is a type of trust that says it's in your trust or in your name while you're alive, and then upon death, instead of it going outright to individuals, kind of like what we did over here, it just said it went outright to the kids. Instead, we say that it goes to the kids in trust. Like if dad set up a legacy trust over here, where instead of it going outright, all 3 shares are held in trust, then we might not even need this trust. But dad didn't set it up that way. So yeah, if it's a ladybird deed, legacy trust, same answers from a capital gain standpoint. What other types of planning disregarding potential tax legislation should we be looking at the end of the year? I sent out via email a sheet. Let me pull it up here. And if you want a copy of this or you didn't see the email, just reply to the email or send us an email and I will email this over to you. But it's talking about just end of year moves. And a lot of these you'll see are tax moves just because it's tax season. So it's an important, that's coming to an end. So there's a lot of taxing. The biggest thing we're looking at is like tax brackets and Roth conversions. Just got off a call with client and we're going to be maxing out the tax bracket by doing a Roth conversion. I have some clients where they're in the 12% tax bracket and we're doing a $25,000 Roth conversion that, yeah, they'll have to pay $3,000 of tax, but now they moved it into the tax-free bucket. Or a lot of my clients have maybe $100,000 or more of income, somewhere in the 22% tax bracket, and we want to fill up the 24% tax bracket. But the biggest thing are really relating to taxes. I guess any big family changes that have happened during the year, maybe we need to look at it from estate planning. Maybe we want to make gifts at some point. But if you want a copy of this end of year issues to consider, just send us an email or reply to email and I'll get it to you. All right. Again, the biggest thing really is just tax planning, is looking at your tax bracket and figuring out either, do I want to do Roth conversions? Do I want to move into IUL? Do I want to just move it to the taxable bucket and invest it there? Do I want to move it to the trust? But really, the number one thing, and I can't stress it enough, is just moving money out of this tax deferred bucket, doing it in an intelligent manner. All right, last question I had. So if you do have any other questions, please put them in now. Can an IRA be included in a beneficiary's trust, or does an inherited IRA have to be issued to a person? Really, that's just getting back to right here. So do you name the beneficiary outright? Okay. Well, then if you do, if there's a divorce, lawsuit, creditor action, bankruptcy, or they pass away, that money could be lost. Versus instead, we leave it in trust typically to them. And we call it a legacy trust or legacy trust provisions. Either way, with the inherited IRA, it is an inherited IRA, so that is important. And the reason that's important is that due to the Secure Act, anyone that passed after January 1st, 2020, if you passed away before, this doesn't apply. The person passed away after, then they're subject to the Secure Act. And what that means is all the taxes have to be paid in 10 years. So if you have an inherited IRA from someone who passed away prior or after the Secure Act passed, which was January 2020, then you have to pay all the taxes within 10 years. So, and whether you name the trust or the individual beneficiary, it doesn't matter as long as the trust is set up correctly. And all of our trusts are set up correctly with regards to maximizing that stretch out. Because we really used to focus a lot on stretching it out as much as we could, and even forcing the stretch. So hopefully that was helpful. All right, any other questions? Any questions? Going once, going twice. Well, let's cross our fingers the rain stops at some point and we can have a few more nice days. So, all right, thank you, everyone.